The Tribunal has not granted leave to Michael Lee to appear on behalf of the Owners Corporation because the Tribunal is troubled and concerned that Mr. Lee is not the proper chairperson or strata committee member of the Owners Corporation. He appeared today and made submissions, including written submissions filed on the 20th of September as amicus curiae or a friend of the court. I think that urgent considerations exist that warrant the making of orders on an urgent basis. So I declined the adjournment request. I think that the parties have had sufficient notice of the orders that were sought by the applicants today and have had an opportunity to put on evidence and have had an opportunity to be heard. Mr. Lee, the purported chairperson for the scheme, put in what he called a statement, but is actually 11 paragraphs of submissions, as well as minutes of a resolution made by the purported strata committee on the 4th of September. So turning to section 231 of the Strata Schemes Management Act, the Tribunal is satisfied on reasonable grounds that urgent considerations justify the making of the orders, that the orders which are Resolution 16 of the AGM of the 14th of August are invalid, and also appointing dependable strata for 12 weeks, which is until the Monday, the 18th of December, for the specific functions of the Strata Committee. Now, the reason that I find there are reasonable grounds that urgent considerations justify the making of the order are that I find that the conduct of the meeting was so egregious on the 14th of August that there are real questions about the validity of all resolutions made on the 14th of August. Some of the issues with the conduct of the matter on the 14th of August, and these are also the reasons why I make an order pursuant to Section 24 of the Strata Schemes Management Act invalidating Resolution 16, are that a secret ballot was conducted. Mr. Lee's explanation as why a secret ballot was conducted, which does not appear to be in accordance with the Strata Schemes Management Act, that's of concern. Of great amount of concern to the Tribunal is the ruling of proxies as invalid. Mr. Lee, as amicus curiae, was able to defend his own actions about why he ruled 87 proxies invalid, and those explanations caused more trouble to the Tribunal than had been presented in the evidence of the applicants thus far. Mr. Lee seems to think that the Secretary is able to refuse to accept any of the documents appointing proxies if they're from an email address that's not on the strata roll, and that is absolutely not anywhere in the legislation or that my attention's been drawn to or that I'm familiar with. That those proxies should not have been rejected by the Secretary and they should have been counted. Of even more concern to the Owners Corporation, to the Tribunal, is the hiring of 7 security guards at the AGM to lock out and refuse entry of persons with a business to be at the AGM. The explanation given by Mr. Lee is troubling, to say the least. He said that the AGM is a private function. I, being Mr. Lee, I pay for the private function and I can exclude whoever I want as the chairperson. The chairperson can stop people entering my private function, which I organise and pay for, so that I can have the peaceful conduct of the AGM, and that's why I lock people out. Now, that is not permissible under the Act. I hope Mr. Lee is still listening. That is not permissible under the Act. If the chairperson wants to have a private function, he can hire a function room and invite whomever he wants and exclude whomever he wants. But that is not the purpose of an AGM. It is not a private function or a party or any such thing. It is an event which should be open to all interested parties. For example, if somebody cared for an elderly occupant, or somebody was a tenant, or the cleaner or the building manager, they should be welcome to attend. If someone's concerned about the votes and the agenda and matters, they might bring their solicitor to sit with them and explain things to them. If somebody has a disability, they would attend with a carer. An AGM is absolutely open to interested parties. but they can attend, and the forcible removal of them is so troubling that the tribunal has no hesitation to say that the resolutions made at the AGM are at all at risk of being ruled invalid. What I was specifically asked to rule as invalid was Resolution 16, which I am about to do, because the tribunal may, on application of the owners who have made this application, make an order invalidating any resolution or election by persons present at a meeting of the owners corporation. And I make that order because the tribunal considers that the provisions of the Strata Schemes Management Act have not been complied with in relation to the meeting. I'm not refusing to make an order. I am making an order. I am deeply concerned. There is no doubt this is a dysfunctional strata scheme. This almost could not be more dysfunctional. It is a very, very poorly operating, if at all, if there's any operations really happening at all in this strata scheme. There is litigation left, right and centre, and there is people conducting, well, the chairperson in particular, conducting himself in a way that is in breach of the Strata Schemes Management Act regulations and the Schedule to the Act. In particular, the financial position of the scheme is dire. This is a 182 lot scheme with works needing to be done. The scheme is in deficit. It has negligible cash at bank, outstanding unpaid obligations, especially for a scheme of its size, and a $600,000 loan debt. The tribunal notes that the evidence of the applicants is not contested. Now, highly relevant to the order invalidating the appointment and also the urgent considerations and also the refusal to adjourn and also the decision not to allow Mr. Lee to appear for the Owners Corporation is Mr. Lee's conduct in now withdrawn proceedings commenced by SG Facilities Management Proprietary Limited. Mr. Lee then purportedly on behalf of the Owners Corporation, and I find he was not properly appointed as Chairperson, Secretary and Treasurer on the 14th of August. He then purported to consent on behalf of the Owners Corporation to a compulsory appointment of the strata managing agency that Mr. Lee's wife owns and operates. That conduct is so improper. It is really troubling to the tribunal that the tribunal did have a moment of considering whether to remove Mr. Lee from the Strata Committee under Section 238, because in actual fact the invalidation of Resolution 16 deals with his removal in any event. But there was no standing of the building manager, SG Facilities Management Proprietary Limited, to ask for an order under Section 237. Having made an improper application, there was absolutely no way or justification for the Owners Corporation to agree to the compulsory appointment of Mr. Lee's wife's firm. And the conditions precedent Section 237, even if SF Facilities Management had standing, were not met, and the Owners Corporation did not apply due diligence at all to giving its consent purportedly through Mr. Lee. And I don't think Mr. Lee even potentially had a strata committee vote on it with the strata committee that was improperly appointed at the AGM in any event. So for all these reasons, I have no hesitation in finding urgent considerations, ruling invalid motion 16 and appointing Dependable Strata Management Proprietary Limited for 12 weeks, which ends on Monday the 18th of December at close of business, which is usually 5 p.m, to exercise specific functions of this Owners Corporation, have and exercise all functions of the Chairperson, Secretary, Treasurer or Strata Committee of the Owners Corporation. I really appreciate you participating in the management of your scheme. I hope you have learned something, Mr. Lee in particular,